Welcome, everyone. Welcome to Cybersecurity Regulations, 7 things you need to know about the General Data Protection Regulation. And thank you for joining us. My name is Marnie Nesher, President of the Business Journal News Network and moderator for today's webinar. This webinar is being This webinar. One second, please. There we go. Sorry. Okay, sorry about that. This webinar is being presented by the Business Journal News Network and Annese and Associates. Some quick housekeeping before we begin. If you have questions during the presentation, please type them into the chat function at any time, and our presenters will answer them at the end of their presentation. Please let me introduce you to our first presenter, Joe Vigorito. He's the Director of Mobility and Security at Annese and Associates with more than 20 years of experience in the industry. Joe is a highly certified and seasoned security professional. He achieved a master's degree in Information Systems Engineering from New York University, Polytechnic School of Engineering, and holds a Bachelor of Science degree in Communications from St. John's University. He is a fellow and diplomate at the American Board for Certification in Homeland Security and is also a member of the American College of Forensic Examiners, ISSA, IEEE, BICSI, and of course, FBI and InfraGard. Annese and Associates is a technology solutions integrator with more than 4 decades of experience in the IT industry. The company has over 150 employees and offices all throughout New York State and serves both public and private sector clients in education, commercial, government, and healthcare. I will now turn the presentation over to Joe.
Thank you, Marnie. Welcome and good afternoon, everyone, to today's webinar topic, 7 things you need to know about GDPR. Just some very brief comments so we can dive right into our topic for today. First, I am pleased to welcome Reg Harnish, CEO of GreyCastle Security, as our main presenter today. Reg and his phenomenal team of cybersecurity experts at GreyCastle are uniquely qualified to speak and advise on a broad spectrum of cybersecurity topics, and certainly the burgeoning EU General Data Protection Regulation is one of the more challenging statutory requirements we've seen in some time. Secondly, as Marnie noted, my company, Annese and Associates, is a 47-year-old technology systems integrator comprised of highly credentialed and skilled engineers, architects, project managers, and senior IT leaders across pillars such as cybersecurity, cloud, data center, collaboration, managed and professional services. Combined with their deep industry cybersecurity knowledge and prescriptive insight, the partnership of GreyCastle Security and Annese, both headquartered in New York State, has delighted commercial, state, local, K-12, and higher ed customers with positive outcomes and flawless execution as companies seek to increase their cybersecurity awareness, assess risk, compliance, management of data, implementation, and securing their information systems wherever they may conduct business. With that, let's get today's topic underway so we can learn how best to comply with the General Data Protection Regulation. Reg, I'll now turn it over to you.
Great, thanks, Joe. Appreciate it. And thanks for everyone for sacrificing your lunchtime for something that we consider important today. I think my hope is to not necessarily present an exhaustive, in-depth look at GDPR, but really the 7 most important things that we consider as a cybersecurity risk assessment, advisory, and mitigation firm. One thing that's important to know is that GDPR is largely a privacy regulation, and that there are a few pitfalls and a few things that are important to know before you endeavor to comply with this, what I'll say, vague regulation. So to get started, GDPR was really introduced by the EU to do one thing, and that is to create some fairness and consistency in terms of the privacy of EU residents. And what happened is that this has cascaded to organizations globally because really we live in a global village today. The world has gotten a lot smaller with the advent of the internet and transportation and lots of other things. And so I expect that we'll see more of this, not only additions or updates or enhancements to GDPR, but also similar regulations from other countries or other organizations as well. before I jump into what I consider the top 7 in defining GDPR, hard to get through this without mentioning at least very quickly what's going on in the EU and globally with this new ransomware. I'll call it an epidemic, although it's actually different than what we saw with WannaCry. Without getting too far off topic, just recognize that we continue to see innovation in cybercrime. And while most of us were, mobilized to deal with WannaCry, certainly with our clients around the United States, and many of us felt like we mitigated that risk, very simple tweaks of a tactic can make us completely vulnerable. Again, and so this is an ongoing situation. Now, what does that mean for GDPR? Well, for us, this is really more of the same. And GDPR, even though the cybersecurity controls aren't specific, what we do know is that to comply with GDPR really requires investment in the same types of controls, frameworks, processes, and user behavioral changes that we've been talking about for 10 years. So if there is a silver lining, it's that if you built a mature cybersecurity program or in the process of doing that and based it on an accepted standard in cybersecurity, chances are very good that you are in a healthy position to comply with GDPR as well as many other industry regulations. So I mentioned the genesis behind GDP. Really, again, for us, the magic is in the translation. And so we have experts who have been through the language, certainly been through a lot of the guidance that has been generated by third parties. And while this is new for us, there are some things that we've landed on and sort of generally agree on accepted principles and practices for compliance. Not all of them are cybersecurity. I want to talk specifically about the cybersecurity suggestions or considerations. I'll touch a little bit on the privacy and just recognizing that privacy and security are completely different. I will do my best to address those as well. So very quickly, the definition of a covered entity is important, right? I assume that most of you who are on this, or all of you who are on this webinar, have already figured out that you are what's called a covered entity and subject to this regulation. Essentially, if you process, store, create, transmit any data about an EU resident, you're likely subject to GDPR. One of the challenges has been not so much recognizing covered entities or identifying which organizations are subject to this, but rather which data, because it is a vast and vague definition. I'll talk a little bit more about some of the specifics, but for us, this is different than EPHI with HIPAA. It's different than cardholder information with PCI in the sense that it's quite undefined. A real quick comparison here for some of the major compliance directives that we deal with and have expertise in. You can see very quickly here that GDPR is not only a bigger mandate in terms of its scope, but it's also, the deadline is coming up soon. Entities is significantly larger than the other regulations that we deal with. And then the assurance in terms of penalties is actually significantly higher as well. You might ask, well, if I don't comply with GDPR, who's going to fine me? How does that process actually work? And I can tell you from experience that that's not well defined yet. And so while this is considered really today a voluntary compliance directive, given that the deadline is not until next year, the reality is if you do not comply with GDPR, it probably puts you, it says a lot about your cybersecurity program in the sense that complying with GDPR actually isn't all that difficult if you've done the right things in the first place. A couple of other things here. 92%, I'm not sure where they got their data necessarily, 92% of US businesses list GDPR as a top priority, but for us, we've seen statistics that suggest up to 85% of the businesses headquartered in the United States are subject to GDPR just because they're working internationally, or they have, let's say in higher education, they've got EU students that visit, or other organizations, whether it's healthcare consortiums or other types of industries that are doing business in the EU or globally, the likelihood that you've got EU resident data somewhere in your environment actually goes way up. So let me get into what I consider the crash course on GDPR. Again, this is very cybersecurity focused, and so there are a number of things that I'll touch on in 60 seconds regarding privacy only at the end of this as I get into some of my final thoughts. The first is this. Important to know that privacy and security are actually quite different. And the analogy that I use is if you've got a sliding glass door and a curtain, privacy is the curtain, meaning you can't see through it, but you can, if it's not secure, you can there's no protection there, right? You could walk right through a curtain even though you can't see through it. And security is the sliding glass door. Security, in this sense, actually enables privacy such that you can see through the sliding glass door, but you can't get through it unless the door is opened for you. Together they make a system, and it's important to recognize, again, that this regulation is largely about the handling of data in a procedural way, and how you allow folks to consent and understand what data you're collecting about them. So this was born of an earlier data protection directive, different than a regulation, whereas a regulation actually does not require any additional legislation to be enacted and enforced by the issuing body. That's a very legal way of saying the EU can come after you at this point whenever they want beyond that May date. However, for those of you who have been around or have been working in an international organization for some time, and if you had taken steps towards compliance with this UK Data Protection Act, they call it DPA, you're probably well on the way to compliance with GDPR as well. So just very quickly, important to recognize that this is about privacy, not necessarily about cybersecurity, even though it does imply some controls. Number two, a plan. I'll sort of bring this full circle at the end of this presentation, but really for the vast majority of organizations who are subject to this regulation and others, there's really three very important things. But the first is having a plan, right? So no longer is it okay to not have understood your risks and developed a security roadmap and been able to demonstrate progress, shown asset owners and demonstrated accountability. You have to have a justifiable, defensible, and documented plan. The first condition is that it should be based on an accepted standard, particularly in terms of the risk assessment. So if you're not leveraging NIST SP 800-30 or NIST 53 or NIST Cybersecurity or ISO 27002 for your cybersecurity controls, you should. You should at least consider those. The vast majority of those controls in those different frameworks are the same. What's different across those frameworks is the organization of those controls and the implementation methodology that's suggested. But each one of those controls gives you, or those frameworks gives you, an excellent place to start for your cybersecurity program. GDPR is exactly the same. It's not an exception. They're going to be expecting that you've adopted one of these globally accepted standards. The second is progress becomes really important. Most regulatory bodies have already figured out that no one is compliant and they never will be. Or even if they do achieve compliance, that's a point in time, meaning tomorrow they may introduce new applications, new people, new locations, new processes that are not compliant, right? Most businesses they change over time. And so compliance is something that is a relentless pursuit, but not necessarily something that we actually achieve. So in the absence of compliance, we have to be able to show progress. Progress is based on a risk assessment, a security roadmap, or your plan, and then defensible movement towards reduction of risk in those areas, particularly at the top of your list, right? Don't be working on the low-hanging fruit. You want to start with your most critical risks. And then obviously the date that you have towards this becomes very important as well. Most organizations tend to wait for someone else to mandate cybersecurity to them. And what happens is now you're in a rush, you're on someone else's timeline, and your budget is out the door because it's not something that's in your control. If you invest in these things proactively, you're in a much better situation. Now, documentation around auditability of your cybersecurity program and your plan comes down to records of processing. And this is, if you think about when this information is created, when it's processed, where it is stored, how it's transmitted, both internally as well as with third parties, you need to have records of how you control and how you reduce risk in each one of those areas. So the documentation becomes a defensible artifact, so to speak. Number 3, really important. Now this can be a lot of work, or it can be your saving grace in the sense that, no different than PCI, if there is a way for you to reduce the scope of your GDPR environment, let's call it, then the amount of work goes down as well. Now in most cases, again, if you've pursued a standards-based cybersecurity program, if you've made progress, you're already working on GDPR requirements as well. However, as I mentioned in the beginning of this, the definition around what's called protected data as it's governed by GDPR is vast. And we've seen some pretty shocking things like political orientation, pictures of the subject that may be posted on social media sites, even things that they call a likeness, meaning I leave residual data, called data exhaust, every day I shop at the grocery store. And so the fact that I like, let's say, Italian wedding soup and not chicken noodle, that is part of my likeness. That information, in some ways, is considered part of the scope for GDPR protection. Again, remember that this is a privacy concern, not so much a cybersecurity. So if you think about the list of things about you that you would not want other people to know, most of that is going to be in scope for GDPR, right? It's no different for EU residents than it is for you. So that'll give you a sense of the sort of the vast breadth of information that we're looking to protect here. This is the one area that is significantly different from any other regulation or directive out there, because most of them the scope is actually much more narrow, much more focused. Certainly in the case of PCI and HIPAA and high tech and some of the other more popular regulations here. Number 4, you must appoint someone who's accountable for your GDPR program. Now again, this can be a subset of your overall cybersecurity program, that's fine, but here's the gotcha. This person, unlike your HIPAA security officer or your HIPAA privacy officer, where these individuals are not required to have any expertise, but simply rather to be accountable, in the case of GDPR, your data protection officer actually needs to be fluent, or in their words, an expert in data protection law and practices and cybersecurity. Now, I could probably count, I've been doing cybersecurity for a couple of decades here, I could probably count on one hand the number of people I know that actually satisfy both of these requirements. My guess is that between now and in May of next year, during the comment period, and certainly in the immediate following months or years after this is enacted, that this is going to be relaxed because these people don't exist. It's certainly not in any significant way. So it'd be real difficult to be able to justify that you've got an attorney who is fluent in cyber and international law, as well as an expert in cybersecurity controls. Literally, these people do not exist. So this is important. The next one is around breaches of this personal data, which is the way it's defined in the regulation. Reporting of breaches is important. Now, most of us have been in a situation where either we have considered reporting due to some undesirable cybersecurity event, or we have actually been through the reporting process. And most of us know that during an incident, we do everything we can to prove that there's not been a breach, right? Because once we use the B word, it's a very legal course following that. And to be honest, this is something that I do on a regular basis, and I can tell you that all of the work that we do leading up to the determination of breach or no breach is equal or less than the work that you have to do after you've determined that it's a breach. So we do everything we can to avoid using the B word, as we call it. There's a couple of differences here with GDPR, very different than HIPAA or high-tech, where breach and certainly disclosure, unauthorized disclosures, there was a reporting mechanism and some mechanics around the who, what, how, why, and when. That all is actually quite similar to GDPR. What is not different is that the types of unauthorized access or exposure, the list is much broader in GDPR. So you can see here loss, right? So imagine that if you're in healthcare today and a laptop with some EPHI, let's say a spreadsheet full of patient records is lost or stolen, if the laptop was encrypted, if we could prove that there was no or minimal exposure, and even if the exposure occurred, that there was no due harm to the subjects involved, that would not be considered a breach. In this case, even a loss, right, the loss of that laptop, despite the fact that it was protected, is considered a potential breach, as well as destruction. Imagine if your own change management procedure failed you and you destroyed, or let's say you deleted a backup or an archive from a time period that violated your own change management or data retention policy, that would also be considered a breach potentially, as well as alteration. Let's just say a medical record, someone went in and changed an allergy from one place to another without supervision or without authorization. That could potentially be considered a breach of personal data. Again, remember that this regulation is about privacy, not about security. So if I went and just changed your bank account balance without actually withdrawing any money, that might be considered something that you think is undesirable. Or if I changed your weight and I added 30 pounds to it, that alteration. Or let's just say I went to your doctor's office and I just deleted your information. I never saw it, I never took it, I never exposed it, but I just deleted it. That would be a concern for you. So breaches have a much broader concern with GDPR. And so it's important, as I go back to step number 3 in classification of this personal data, we want to make this environment as small as possible. Very similar to how we do scope reduction for retailers with PCI, and we isolate and we outsource and we do a lot of other things. We want to start to consider these types of tactics and strategies for GDPR compliance as well. One more consideration here, a breach is reportable. You can see the definition here, likely to result in a risk to the rights and freedoms. Right, so we go back to any other regulation today, anything that we're familiar with. This is really about exposure or the compromise of confidentiality, integrity, and availability. In this case, a risk to the rights and freedoms, I have no idea what that means, and I'm guessing that most of you are probably scratching your head right now as well. As it relates to breaches of GDPR and personal data, my suspicion is that there's going to be a lot of court precedent that defines this thing on the fly, meaning we're not really sure how to best prepare for reporting breaches with GDPR, and we're going to have to see how this thing plays out. In the meantime, we want to do everything else we can to avoid breach, and certainly there are some tactics here, of course, the top 7 here that will be important as well. And then the last point for this topic is that there's this very specific deadline, and the clock starts ticking as soon as you know or you determine there's been a breach. So very often there's a timeline for incidents or intrusions or breaches where the first phase is undetected, and so adversaries have compromised your network. Maybe they're stealing data, maybe they're doing other things, but there's a period of time where our adversaries have access to things that they shouldn't have, and we don't know it yet. The second phase is post-detection, right? So now we're in response mode. That middle phase is where we know about it, we know it's happened, and we're working to resolve the issue. The third is, once we've determined that there's been a breach, and there's a whole bunch of other work, the clock starts ticking at that moment, right? So the moment your attorney determines that your case is not defensible and that breach must be declared, the 72-hour clock starts ticking, and you have up to 72 hours to report. And there's some very specific, you need to report to, it's called a supervisor. I think it's the personal data supervisor. It's a body of the EU, and there's probably a few others that are specified in here. Now, again, sticking to the cybersecurity aspects of it, there's a few burdensome aspects here that if you're not in healthcare, so healthcare has been dealing with right of access for some time. We call it something different. But the right to my patient records and my patient information, my patient history, that's actually a right that's granted to me both through OCR guidance as well as HIPAA with transference of data into portability in EDP in HIPAA. This is actually very similar in the sense that a covered entity must be prepared to provide this information when it's requested by an EU resident. And you also must be willing and capable to describe how you're collecting it, how you're processing it. And so I go back to those document of practices, the processing. Those become artifacts that are leveraged here in this right of access requirement. Again, an EU resident comes and asks you, hey, I want to know what data you have about me, and I want to know how you're using it. You have to be able to provide detailed processing directives around each one of that data. Secondarily, the right to erasure. Now, this actually changed. So if we go back to the UK Data Privacy Act, there was a directive in there called the right to be forgotten, and they felt like that wasn't deep enough. In this case, forgotten can be interpreted as so. Like Facebook's a great example. If I go and disable my Facebook account, the data doesn't go anywhere. Facebook still has all of it. I can actually go back in and re-enable my account 2 years later, and all that data is still there. However, in the meantime, in that 2-year period, Facebook can hide me. I wouldn't show up in search results. I wouldn't show up in posts. I wouldn't show up on other people's walls, because I've essentially been forgotten, but I wasn't erased. They've taken it a step further here, and there's actually a stipulation to this that's even more burdensome. So not only can a EU resident request that you actually erase their data, this means physically destroying the bits and bytes on a hard drive, but in addition to the personal data, the language looks like it's also specifying that incidental data. So for example, let's say I go to the grocery store and I buy Italian wedding soup. Not only the information about my trip, my travel, the time I was there, the soup that I bought, the price I paid for it, and my preferences, my shopping habits at that particular grocery store, that's the obvious stuff. But now the GDPR is also suggesting the fact that I shop on Tuesdays on a regular basis. And other incidental data that is either generated, we can consider it metadata today, that also has to be included as part of the data that must be erased as part of this request. Again, a lot of gray area here. We're not exactly sure what the definition of that is, and I suspect that there'll be some gnashing of teeth as we get through this and the enforcement starts after sort of Q3 of next year. Now here, I would suggest is one of the silver linings for any of you who have begun pursuing an effective, mature cybersecurity program that's based on standards, that's measurable, that is risk-based, where you've developed a security roadmap and you can demonstrate progress and you've made people accountable, on and on. Because here, this is really about protection and privacy by design. So for us, we know, and we've been able to prove countless times, whether it's in court or to third parties or for certification bodies, that pursuance of a standards-based cybersecurity program is really considered cybersecurity, or in this case, protection by design. There's a catalog of controls. Each control addresses a specific risk area. Right, the process of managing or assessing risk in those controls is very it's prescriptive. We understand how it works. We've been doing it for a long time. So again, this, which is potentially one of the biggest in terms of expense, budget, labor, one of the biggest issues, the biggest areas of GDPR is something that you're probably already pursuing today and may not have to make any changes at all. Certainly from a cybersecurity program if you're doing those kinds of things. Now, another saving grace here, and perhaps a silver lining, is that the controls that you define that are specifically designed to support privacy or provide some assurances around privacy and your privacy practices, they're defined by you. So no different than a SOC 2 type audit where you're defining what the process is that needs to be protected, right? How do you interact with third parties? In this case, you could define the controls for your organization that are being implemented, so whether it's access controls or encryption, whitelisting, a change management process, an incident response plan. Each one of these controls may be defined as supporting your privacy by design protocol. And so it's nice that you get to define that. Of course, because you're the body that is defining this, you also have to put yourself in a position to be defensible, right? You got to be able to defend your design. But it makes sense, and we see more and more regulations either being implemented this way or changed so that really the design is up to the implementer, but also the accountability goes with that as well. So let me go over a couple of things here that I consider important final thoughts. And the first is that in industries that have been dealing with regulation for a long time, like healthcare, the practice around compliance is really no different, right? You do a risk assessment. Well, first you define scope, you identify your asset inventory, whether it's EPHI or it's personal data of EU residents. You define your scope, you conduct a risk assessment, you move from assessment into developing a security roadmap for risk mitigation, assuming you've already defined your risk tolerance as an organization, and then you show progress, right? The same exact thing is true for HIPAA compliance as it is for GDPR compliance, in the sense that you have three things to do. Do a risk assessment, build a security roadmap based off your most critical risks that come from the risk assessment, and then three, be able to demonstrate progress and be prepared to defend your progress to anyone that's interested in seeing that, certainly a regulatory body. The same is true for GDPR, right? If we're pursuing for leveraging standards, we're doing a risk-based, we've got a risk-based program. We're looking at people, process, and product, not just technology. We're not making this an IT issue. This is a business function. You're in a much better situation from the outset than if you had, thought of cybersecurity as an IT function or hadn't leveraged a standard like NIST 53 for your controls framework. So if you're in healthcare, you've already got some muscle memory here, and so this is no different. That's good. I would suggest that the same is true of any retailer that's on the phone, manufacturers, critical infrastructure around SIP. A lot of the sort of the pursuit of compliance is exactly the same. Compliance date, May 1, 2018. They have not suggested what enforcement looks like, so different than what we saw from OCR and CMS with HIPAA and high tech. They've talked about maximum penalties. They've talked a little bit about how assurance might be conducted, meaning the audit procedures. But we've seen no evidence, one, that they're capable of auditing or even assessing organizations, or two, that this is any more than a political move on the EU's part, in the sense that they've got a different society. Privacy is very different in Europe than it is in the United States. That said, again, if you look at GDPR and you say, I really can't comply with this, what it means is that you've got problems in a lot of other areas, particularly if you're in healthcare or in other places like higher ed. Higher ed is a very privacy-focused industry with FERPA and other directives. If you can't comply with GDPR, it means you've got other issues. And so I would suggest that you look at your cybersecurity program as a whole and think about, how do I kill multiple birds with one stone? You do not need to recreate the wheel with GDPR. Your current program probably satisfies a certain percentage of this. And there are some outliers, right? Again, defining scope and personal data. We've got some problems there. We've got some challenges. We've got some challenges around breach reporting, right, detection, reporting, and notification that are different than other regulations. But the basic foundation of this hasn't changed for 20 years. We figure out what's important in our business. We make a list of those things. We assess the cybersecurity risks to those things. We have a plan for mitigating and reducing those risks to an acceptable level, something we're okay accepting, and then we repeat. And it's literally identical to everything else that we do in cybersecurity. So if you're responsible for GDPR compliance in your organization, go back to your cybersecurity program and take a look at what you're already doing. Line those controls up, right? No doubt, and certainly GreyCastle Security, one of the things that we provide to our clients is a matrix of controls that help you prove compliance across industries and across regulatory frameworks. Try to do the same thing with your program, right? Look at whether it's privacy, whether it's encryption, it's access controls, it's identity management. Look at all those things and say, well, what am I already doing? And how can I defend my compliance, my GDPR compliance with controls that I already have? Save yourself some time. Also, you may want to think about, so if one of the things we build for our clients is basically an auditor's playbook, which is, here's the risk assessment that we did, here are the standards that we based it on, here are the risks that we found, here's the roadmap that was derived from those risks, and here's the progress we've made. If you put it in a 3-ring binder or a single PDF, go back and take a look at that and figure out, well, where are the outliers here for GDPR, and what are the smaller places that I need to enhance in my audit playbook that help me defend my GDPR program. I think I've beaten this one pretty good, but the big 3 are risk assessment, right? You got to do one. Security roadmap, you got to have one, and progress. You got to be able to demonstrate. If you can do those 3 things, you're immediately in a position that is defensible. What I would say is, not unlike a lot of other industries where we see regulators or federal government auditors getting involved, is there are so many fish to fry right now that if you can drop an audit playbook or a regulatory playbook on someone's desk, it's a 3-ring binder, and you've got evidence of your risk assessment and all these other things that we've discussed, your auditors are probably going to say, we might as well move on, right? We've got bigger issues. And so this just sort of sets you up for success in cybersecurity no matter what it is that you're doing. That's my story. I'm sticking to it. I will turn it back over to you for questions that might have come up.
I don't, we're welcome to take questions right now. If anybody would like to, just type it right into the chat function. Don't see anything. Okay, 1 second, please. Joe, do you have any comments you'd like to add while we wait for questions?
No, I actually will ask a question. So, Regin, and this may not yet be defined or clear, but let's say an organization does business in the UK. Has the EU or the UK announced how GDPR will be handled in a post-Brexit milestone era, or, again, in using the bigger fish to fry, they just have not tended to that particular item as of yet?
So we've already seen some legal comment from a couple of attorneys that we trust in cybersecurity that suggest UK residents will be excluded from this regulation. That's assumed. We sort of have to see how Brexit plays out. But today, if you take each at their sort of stated definition, a UK resident is not an EU resident, or they will not be, and so they would automatically be excluded.
Great. No, thanks, Reg. One more. I would bet that we probably have some attendees on the phone who also fall under New York State GFS 23 NYCRR 500. In terms of the data breach guidance in GDPR, Reg, is it safe to say that if I've got a data breach that I need to report under GDPR, I probably have something that needs to be reported in 72 hours under DFS as well.
Possibly. Keep in mind that the data that's in scope for GDPR is much broader than what Department of Financial Services has listed as in scope for what's called financial entities, financial institutions, or those that are conducting that kind of business. So I would say that's not necessarily true. Yeah, I would say it's not necessarily true. However, you can leverage the same basic breach, so incident response and breach notification and reporting procedures for both, but they have very different scope in terms of the data that they aim to protect.
Got it. Great. No, thank you. Anything, Marty?
No, I don't see any other questions at this time.
So yeah, one last one, Reg. So dealing with the issue of transparency under the regulation, organizations need to provide extensive information to individuals about the processing of their personal data. And it needs to be presented in a concise, transparent, intelligible, I'm taking words from the rule, intelligible and easily accessible way. Do you see organizations kind of building their own, have you heard about this, building their own data marts so that data subjects can come in and regulate their own data and say, checkbox, no consent on this one, I'm taking away this right, I don't want to get emails from you, I don't want you holding my email address, I don't want you, there's no mailings that need to come to me, so, take away my home address. Do you actually see organizations getting so concerned that they're actually setting up data repositories that their data subjects, their customers, can come in and query and remove their own information?
Not necessarily, but there are some, I would say, similarities to, let's say, a safe unsubscribe in an email, which is, one, it's end user generated. That activity is end user generated. So if I request of you information about what you track for me, what information you have about me, how it's processed, stored, transmitted, created, and I'm not happy with the details, we're not exactly sure how an EU resident what recourse they might have. So there's certainly some gray area there. But most organizations don't have the kinds of documentation available today about how they process. Mm-hmm. You know what I mean? It tends to be an IT function or something they're doing in marketing or for analytics in healthcare. And it's not. I think a lot of this stuff goes on, and there's not a lot of documentation that would be easily consumed and accessible by an end user. Even your patient record, you could argue that. So I have access to my patient portal, but today all I see is the end results. I don't see how it's processed. Like I don't have access to the EMR. I don't get into PACS systems and clinical systems to understand how that data is moved around. And so I do think there's going to be some burden for organizations around creating these artifacts, but I also suggest that these are healthy to have and probably something that can be leveraged to improve your business, not just provide GDPR compliance. So it's additional work, but I think it's a good practice.
Yeah, no, that's great, Rich, and that ties directly back to this notion in the rule of consent, where it says different processing activities have to have their own consents associated with them. So if one activity is to, process an insurance policy and the other activity is to set up an annuity, that might be two different processing activities, both of which require the consent of the data subject. So no one should assume that just because I said yes to one process means I've said yes to everything. It's basically what the rule is saying. You've got to come to me every time and tell me what data you're collecting for each process you have.
Yeah, I would agree that that's correct. I also think that organizations, as this matures and we see where this goes, can achieve some success by thinking about this like they did with PCI, which is Right now, I'm going to take every bit of PCI data out of my data center, and I'm going to create a new environment, a tiny, small, focused environment with my credit card and cardholder information, and I'm going to apply different controls there so that the scope of this regulation is smaller. Because I don't want to spend the same amount of time protecting, my public website as I do personal data. So isolation and segregation of this data is certainly a potential strategy, depending on what kind of organization you are, right? So, I think about some of our higher ed clients who they have EU programs or programs that are conducted in the EU where there is some EU resident data there, but it's so small that it would not be that burdensome to take that data and move it somewhere else and protect it differently, just so you can point at your GDPR environment separate from everything else.
I do have one question.
Oh, yeah, absolutely.
And someone had asked if you could just share what the GDPR stands for again.
Yep, General Data Protection Regulation. And again, it's a new an enhanced version of the UK Data Protection Act. So if you just Google UK DPA, generally it comes up, and you can see some of the roots of this, the language there. There's not a ton of good legal interpretation out there yet because it's so new, but no doubt that will start popping up. And again, the attorneys, the law firms that we work with on a regular basis for these kinds of issues, they're already starting to do their own interpretations and track court, case precedent and that kind of thing.
Sure. And I think probably a worthwhile point, Reg, is make sure if you're going to speak to an attorney that they have some experience with international enforcement of international law on organizations that operate in part out of the U.S., but also have either operations, clients, or sell products in the Eurozone countries. Don't go to
absolutely.
a commercial attorney and assume they have a handle on this.
You make a great point, because I think, there's an additional layer of complexity and confusion here because everyone wants to put cybersecurity on their website, right? Everyone wants to be a cybersecurity expert today. CPAs and law firms and insurance carriers, they're all talking about cybersecurity and how they can solve your problems. You got to look past that. That's all noise. You want to go to someone who's a specialist. Don't trust an attorney that is, specializes in real estate or, contracts or, marital law. You want to go to someone who's actually been there, done this, has experience, has the chops to help you. Otherwise, what are you spending your money on? And we're in the same boat as a cybersecurity firm. That's all we do. We see so many companies that are trying to get into the cybersecurity space that are not doing their clients any favors. So yeah, absolutely, it's no different in the legal realm.
Absolutely, it's the same rule of thumb, that we talk about in the realm of cyber insurance. Don't go to somebody who's never written or underwritten a cyber insurance policy before. That's probably
or more importantly, someone that's actually successfully paid a cyber policy claim.
Yeah, and we're starting to see more and more of that. Now, a year or two ago, there were very, very few cases that had been litigated where payouts had been made. Now, obviously there are many, many more. So now you can find that out pretty readily. It's a matter of, in large part of record.
You got it. So I'll just close by saying GreyCastle and myself in particular, we offer a lot of free information online. If you found this interesting, please connect with me on social media, follow me on Twitter, or subscribe to my blog, and that's the stuff that we give away for free.
Thank you, Joe. Yeah, thank you, and thank you, Reg. Thank you, everybody, for attending this afternoon. We will be sending out a survey with a link to the presentation afterwards. We hope the content was informative, and thank you for joining us, and enjoy the rest of your day.
Thanks, everyone.